Is a successor trustee required to notify beneficiaries? Have you ever wondered what happens when a successor trustee steps into their role? One important question that often arises is whether they must notify the beneficiaries. Let's break this down. When a successor trustee takes over, especially after the original trustee has passed away or can no longer fulfill their duties, notifying the beneficiaries is typically required. This notification is not just a courtesy. It is often mandated by state laws as part of trust administration. So, when should this notice be sent? Generally, the successor trustee must provide notice within a specific time frame, which is often between 30 to 60 days after they assume their role or after the settlor, the person who created the trust, has passed away. This ensures that beneficiaries are informed in a timely manner about the trust and its administration. Now, who exactly needs to be notified? The successor trustee must inform all qualified beneficiaries. This includes primary beneficiaries named in the trust, contingent beneficiaries who may receive assets under certain conditions, and sometimes even heirs of the deceased settlor. This way, everyone with a legal interest in the trust is kept in the loop. What should the notice include? The notification usually needs to contain essential information. This includes the name of the settlor, the date the trust was established, the name and contact information of the successor trustee, where the trust is being administered, and instructions for beneficiaries on how to request more information or copies of the trust documents. It is important to understand the legal consequences of failing to provide this notice. If a successor trustee does not notify beneficiaries properly or on time, they could face legal and financial liabilities. This might include challenges to the trust administration or claims for breach of fiduciary duty. The purpose of this notification is to promote transparency and accountability. It allows beneficiaries to understand their rights and the status of the trust. They can also monitor the actions of the trustee, ensuring everything is being handled appropriately. There are some exceptions to this notification requirement. If a beneficiary or heir cannot be located despite reasonable efforts, the trustee may not be required to send notice to that individual. Additionally, the trustee may rely on judicial determinations or make good faith efforts to identify heirs. From the perspective of elder law and estate planning, it is essential for successor trustees to understand their obligation to notify beneficiaries. This duty is a key part of protecting the interests of beneficiaries and maintaining the integrity of the trust administration process. It aligns with the trustee's responsibility to act in the best interest of the beneficiaries and keep them informed about the trust and its management.